erstwhile sidekick Chris this week while he has a week off. And I suppose it probably helps because I'm still in quarantine along with the rest of my family, pursuant to my daughter going to a school that was exposed to COVID. So how people survive in a hotel room for 2 weeks is absolutely beyond me. But here we are. So week and a half to go. And today we're doing a very specific management rights one. So this, for me, is probably one of the most common things we do as lawyers and questions I get asked about from clients as well as everyone else. So it's about extensions, variations, top-ups, options, which are all sort of words that are used interchangeably in the management rights sphere. But today I've got half an hour of just talking to you about what they are, how they work, and all that sort of stuff. So what I do have behind the scenes today is Annie, our marketing manager, who's not actually on the screen, and nor will she be. She's going to pop up 2 links now in the YouTube feed in the comments section. So the first one is a document upload service, which I'll talk about, or a link to a document upload, which I'll talk about as we go through this. And the second one is a link to where you can post questions after this webinar. So if you're not watching this live, which is Thursday afternoon, 2 o'clock on the 12th of August, you can pop a question to that later on and we'll come back to you. So they're the most important things at the moment to get up there. So today's session is based more talking to resident managers about really their management rights agreements, but it's got equal relevance, I suppose, in a sense for bodies corporate and body corporate committee members and lot owners to understand how management rights agreements work, because we've still got this very large, effectively unsophisticated audience in some degrees who happen to buy a unit and don't understand what management rights agreements are. So if you found your way to watching this, then welcome. So let's start with, I suppose, the fundamentals. A management rights agreement is a contract. Simple, entered into between a body corporate and a manager. Now, those contracts have terms, the same as a lease. So that's the analogy I'm going to use for this little part of this conversation. And it probably falls out of the back of the motel industry to a degree, but a management rights agreement is not a lease, but it's got some of the same fundamentals. So that is that there's an agreement between 2 parties which goes for an actual period. So in management rights context, we've got 2 things that are really relevant in terms of standard residential management rights. They're the modules that your building might be regulated by. So under a standard module, a management rights agreement can be for a maximum term of 10 years, and under an accommodation module, it can be for a maximum term of 25. If you happen to be in the commercial module, which is really retail and obviously office strata, then that's also a 25-year maximum term. Now, whether the agreement goes for that term is something else entirely. And so one of the things that happens is that these things are entered into and they're varied over time. So one of the things that I suppose this is a bit of a family job, this one, is that we've been doing. So I've got a 13-year-old daughter who used to use Lego a lot. We haven't got rid of it all, given most of it away, but we found a little bit. And my wife has exercised her creativity to come up with this prop today. So if you look at it like that, let's pretend for a minute that that's a 10-year period. So at some stage we'll do this as an animation, but for right now, this is what we've got to do. So that's a 10-year period. So it might start on the 1st of June 2021 and expire on the 31st of May 2020 or 2031, 10-year period. Now, if it's a straight 10-year term, all well and good. What quite often happens, though, in management rights is that these things are actually broken down into an initial term and an option period. So let's take this particular agreement. We've got a standard module agreement. It's a 5-year term with a 5-year option period. So what that means is that if this option is actually exercised, then the agreement goes for 10 years. But what you need to do is actually exercise it. So that's the first thing I'm talking about today, is exercising options. So the next thing I'm going to be talking about is, again, we've got this agreement, and just because it makes it nice and easy in terms of zeros, let's say it started in 2020, ended in 2030. What happens is that obviously over time, the agreement expires. It disappears. So when we get to 2025, what happens, if the Lego doesn't break, is you've only got 5 years to go. So what has to happen, or what should happen from a management rights perspective, is you want to make sure that you go and add another period at the back end of that agreement, which is this little new purpley one, to take you from 2025 through to 2035. And that is a variation to the agreement. So that first one, our yellow one, what we've got to do is actually exercise this option for it to come into existence if it's broken up that way. And then what we've got to do after that is to add more term to it. And they are two completely different things. So it's the same as a lease. If you're in a Westfield, you've got a lease from Westfield for your actual shop. It runs for 5 years. At some period of time, you'll go in there and say to Westfield, hey, I'd like to get some more option term, please. And they'll grant that to you or they don't. And that is one of the key things for management rights, because if you don't exercise, I'll click my Lego back together, that yellow option, your agreement comes to an end. So then you've got nothing. But not reframe that. You've got nothing. You own the unit. If you own your unit, you've got a bunch of letting appointments and you've potentially got a month-to-month caretaking agreement. So the first thing I'm talking about today is actually exercising your options. So what that yellow thing is, that's a contractual right that you've got. So it's there, it exists. And I suppose one of the things with management rights, as we always get, is that there's no standard form management rights agreement in the industry. None whatsoever. So what happens is that people, lawyers, putting together off the plan, press buttons, out comes a precedent document. And one of the questions we get asked all the time is, why is it broken up into term and option periods? Why isn't it a straight 10-year term or a straight 25-year term? And really, usually, when they're first being drafted, it comes down to the intentions of the parties at the time. The manager and the body corporate might be changing things, but over time, as agreements run down and then get added to, if you only had a 10-year agreement, what you might be doing is adding 2 years at a time, and then 3 years at a time, 3 years later, and so on. So over time, they break down, and there's these triggers that you've got to do as we go. So what Annie might put up now is a link to a newsletter I wrote about the difference between an extension and a variation, which is for people to look at later on as well, as much as I'm talking about it now. So as much as there's no statutory basis for having different terms and options, it's purely a contractual one, and it just happens over time. So what they are, though, in terms of exercising options, is effectively landmines that people can forget. Because particularly in a management rights context, particularly when you're buying one of these businesses, there's paperwork flying everywhere, there's figures reports, there's legal due diligence reports, there's finance approvals, there's obviously moving, there's running the business, and there's all that sort of stuff that comes into it. And you might settle today and have an option to exercise in 2025. And it is the easiest thing in the world to forget. But it's the most critical thing to remember, because if you don't exercise it, your agreement potentially comes to an end. So back to exercising it, each option can be drafted differently. So again, because there's no statutory standard, there's no standard form option clause. So some of them will be self-exercising. So some might say, unless the manager surrenders it, the option's automatically granted. Most, though, will require the manager to give notice to the body corporate, usually within a specific period, and usually at least probably 3 months before the agreement expires, to trigger the body corporate to bring that option into existence, so to physically exercise it. And that can be as simple as sending a letter to the body corporate, and voila, away you go. So the main thing, though, is that you actually do exercise it. So you need to understand what it is. And even this morning, one of the things we do, and that's back to pitching what that first link up there today is we remind clients to exercise their options. And I don't think anyone else does that in this industry, because I've seen too many clients come croppers, and usually other lawyers are failing to exercise them. And even I had one client email me this morning about, Frank, I think I'd exercised my option by the 4th of August, which is 8 days ago. And it's like, my goodness, how on earth did that happen? But she had a self-exercising one. So the way that worked is, unless she surrendered it, it automatically comes into existence. So at that stage, I could calm myself down and we're all good. So those options, a notice needs to go to the body corporate. And then for me, in theory, there doesn't need to be an actual deed of extension that goes with it that records the exercise of the option, but I think it is definitely best practice to make sure that happens, because the unfortunate reality of life is that sometimes things get lost. Notices of exercise of option get lost between transfer and body corporate managers, body corporate records. Some people keep things electronically and some don't. And particularly when you're looking for something that might have happened 4 years ago, it is a hell of a lot better to have a signed deed in which the body corporate acknowledged that the option was exercised in time, and that the period is extended for whatever it is, for that yellow block there. So if you don't do that, you just run the risk of it potentially getting lost, and that is dangerous. So probably the other thing is that if sometimes you might have forgotten to exercise the option during the period, but the agreement hasn't actually expired yet, there are some things you can do to try to get it changed at general meeting to allow that to be exercised before the agreement expires. But once the agreement's expired, it gets really, really hard to bring that agreement back into existence. So these things, if they're not done right, are catastrophic. And you'd be surprised from a management rights perspective, because obviously, if you own management rights, you're investing a lot of money in your business, but so are the banks. The banks have usually lent people 50, 60% of the value of the business. So they are more exposed than what you are. And I have pitched, believe it or not, this service to banks to say, you lot should have something in your system that does this, and we've created a product internally that allows it to happen, and I can't get any of them to buy it. So because the banks are actually just as exposed as the managers are, in the sense of if these agreements expire, then their capital or their loan is distinctly at risk. So I've just seen some questions over there. Ron, I'll get to both of those in a minute. So I think I'll probably get through the options. So if you don't know whether you've got an option, that's your first question that you need to answer right now. And if you do then find out when you've got to exercise it, what you need to do is make sure you make a notation somewhere that you will be reminded of that you have to do it. And if you're not sure to back yourself on either of those, then upload your documents as per that first link that Annie's put up, and we can go from there. And for those people that are clients of ours who we've acted for, you're already in the machine. So don't worry about you doing it, but if you're not a client of ours, then absolutely we can do that for you. So moving on, the next thing then is adding this purple, adding this third 5-year term. So probably if you're going to describe it, an option is the exercise of an existing right. So it's an exercise of an existing contractual right that you've got. The creation of another option period is the variation of the agreement to create a new right. So it's not something that's automatic. So probably what we say to clients is obviously not adding further option term doesn't have as catastrophic impact on your business as failing to exercise an option does, but over time it can whittle it down. So the reality is that in management rights, and this is a famous phrase from an industry valuer who's no longer in the industry, certainty equals value. So in a management rights sense, we have these nebulous multipliers, 4 times, 4.5 times, 5 times, whatever it might be, which is another way to describe a return on investment. But it's pretty safe to say, and I just put this out there, I'm not a valuer, but if you've got 2 buildings side by side that are, for all intents and purposes, identical, we have the same level of caretaking remuneration, we've got the same number of units in the rental pool, we've got the same caretaking duties, we've got the same manager's unit, amenity, aspect, size, value, and all that sort of stuff. If the one on the right has a term of 3 years and the one on the left has a term of 20 years, which one is worth more? And I think the answer to that is pretty obvious. How much more it's worth is absolutely not for me to say. And it's more secure. So the longer the tenure you've got, the more secure your management rights business actually is. So from a management rights owner's perspective, it's really important to stay on top of making sure that you're aware of what you need to do to top those agreements up. So what we say to clients at really in a standard module building, ideally you don't want to have less than 7 to 8 years to run. In an accommodation module building, probably you might let it get down to 20, as much as we sometimes top them up earlier than that. It's really a question for each client individually. And probably the other thing I'd say is that one of the things we do is we prompt clients to do this when we think the time is right for them. Sometimes people say, I'm not looking at selling this year and I won't bother about it, et cetera, because obviously the more term you've got, the more saleable your business potentially is. And you just go talk to management rights brokers about that. One of the things that happens, particularly in a market that's relatively warm, which is what this one is that you might get a knock on the door with someone making you an offer that's too good to refuse. And if that's the case, one of those things is ideally having the maximum term available to you ready to go. Because I can tell you now that there's enough moving parts in a management rights transaction as it is, with figures, legals, finance, body corporate approval, and so on, without varying your agreement to add further term to it as a condition of the sale. That's one more complication. If you can avoid it, it's a wonderful thing to avoid. Because it takes time, takes effort, and effectively what you are doing as a seller is asking the body corporate to grant you something to sell it straight on to someone else. And sometimes that's a hard thing to sell in a figurative sense. So if you can get your top ups out of the way before you're selling, it's a much better place to be. So probably what the next thing I might start with or comment on are some common misconceptions. Now, I get these a lot, so I'm just going to run through these in terms of these are things that have been rattling around in the industry that I would get every other week almost, because we would top up maybe 10 to 15 clients a month, varying their agreements and all that sort of stuff, and I get these all the time. So the first one is that your term or the maximum term your agreement can run to isn't capped at what the original agreement was. So if you had an accommodation module agreement that was originally for a 20-year term, that can be 25. You can go past what the original grant was, provided you're inside that statutory cap of 25 years. I get a lot of clients saying to me, but it's only ever been a 20-year agreement. Well, it can be 25. That's what the Act allows you to do. So don't think you're capped at whatever the agreement originally was. Unlike exercise of options. So when you're exercising an option, you give a notice to the body corporate, and in theory, it's done. What we say to clients, as mentioned before, is you go get a deed signed to make sure that that exercise of option can't actually be lost. Body corporate puts pen to paper, and from a body corporate perspective, for the seal to be affixed to a document, there must be a resolution of the body corporate that authorises that. So when we do that for clients, we give the body corporate the motion to resolve to enter into the deed, but that's at committee level. Varying an agreement to create further option term has to happen at general meeting level. It cannot be done at committee level. Full stop, end of story. The Act is very prescriptive on that. So from my perspective, that's ideally at an AGM, but it also can be an EGM. So your AGM is your annual general meeting you have once a year. Your EGM is any other general meeting that's throughout the course of the year. And for that variation to be passed, you need an ordinary resolution. Now, the key thing here is an ordinary resolution is more votes for the motion than against it of those who choose to vote. It's not half of the owners. It's half of the owners who vote. So in a 100-lot building, you might have only 3 people vote, and if 2 people are in favour and 1 is against, you win. That's the body corporate democracy in which we live. So it's not half the owners, it's half the owners of those who choose to vote. The other one is that if you own a lot, or in fact, if you own more than 1 lot, you can vote in favour of your own motion. So there is no such thing as a conflict of interest in voting at general meeting. At committee level, absolutely there is. At general meeting, no. Because in fact, everyone in theory has a conflict of interest in voting at general meeting, because everybody corporate decision, everyone's going to have a stake in. So you do get the chance to vote for your own lots. Another one is that unless you own a lot, only people who own lots or the committee can put motions up to general meeting. if you are a management rights that's a business only, you need to either have the committee agree to put your motion up, or you need to have a lot owner put it up for you. You can't put a motion to general meeting purely as a contractor. And in that sense, you're no different to what we are when we act for bodies corporates, is we can't, Heinz Legal can't put motions to general meetings saying that we engage Heinz Legal for the next 12 months. It'd be great if we could, but we can't. So, and you're exactly the same if you don't own a piece of real estate. Now, some of the anti-management rights bodies, and a few of those that lurk around, one in particular, but I'll leave them nameless for the moment, would like to think that you can put it, that they can put a motion, or an owner can put a motion to general meeting to prevent the body corporate from considering the variation to a management rights agreement. That can't happen. The way the legislation works is the Act says if an owner puts a motion to general meeting, barring some very, very rare exceptions, it's got to go to the general meeting. So if a motion goes in, it's got to go on the agenda. End of story. Now, the other two things are probably things that, again, surprise some people. Bodies corporate are not obliged to grant top-ups or variations to management rights agreements. They can vote no. And in that sense, I suppose there's a whole bunch of material I've got on that that isn't on our website yet. So if you're interested in some more deep and meaningful seminars I've done in person on that, just pop into that second link, which is the questions where you can ask for it, and I'll send it through to you. And the other one that gets popped up from time to time, and we know, and Chris and I talk about it all the time, is body corporates have a statutory obligation to act reasonably. Some people suggest to me that it's unreasonable for a body corporate to refuse a top-up, and others people suggest to me that it's unreasonable for a body corporate to grant a top-up. I don't think either of those is actually correct. The Act allows it to happen, and if it happens, it happens. So I don't think it's unreasonable one way or the other. So having dealt with those misconceptions, let's talk about the top-up process itself. So when you do it, I think is, as I mentioned before, that standard module, 2 to 3 years into your agreement, so you can get back up to 10. Accommodation modules, probably about the 20 mark. The way body corporate voting works is that every body corporate has an end of financial year. That end of financial year is not the tax year that we all live in, which is 30 June. It's tied back usually to the month the body corporate was first registered. So it can be any one of the 12 months of the year. And what happens is 6 weeks before the end of that body corporate financial year, the body corporate manager must invite from all owners submission of motions, and also invite owners who want to be on the committee to nominate for the committee or the committee positions. That's the trigger for thinking about whether you need to do it. So if you lodge that motion before the end of the body corporate's financial year, it's got to go on the agenda for the AGM, and the AGM must be held within 3 months of the end of that financial year. So if we've got a 30 June financial year end, the AGM's got to be done by the 30th of September, and your motion must be on that agenda. So you get that right to do that as a lot owner every single year, as does every lot owner, with whatever it might be, bylaw changes, etc., etc., etc. So the process itself is a little bit more complicated than exercised in an option, which in theory, again, is just that notice deed. What you should do is actually you need to have a proper motion to put to the body corporate. You need to have a deed of variation. So you need to make sure that all of the wording that you've got in your new term is consistent with your existing agreement. And you also need to have a statutory form go with that. It's called a BCCM Form 20 that sets out some basic stuff that the government has decided that owners need to be informed about. And that document needs to go with the agenda for the general meeting to explain what it is that you're asking the body corporate to do. I had a client not that long ago ask me, can I do this myself? And I said, absolutely you can, but I bet you stuff it up. So I'm trying not to be too facetious here, and obviously that's a very subjective thing to say, but it can be complicated. And I see other lawyers make mistakes in it. So for the sake of less than $2,000, which is what these things are, it's a form of insurance, really engaging a lawyer to do it. The other thing that happens with variations, and it's probably getting less and less now, but Gallery V is still something that needs to be dealt with. So Annie will put up a newsletter there for Gallery V. That, I suppose, we're through the end of that. When we're varying management rights agreements, we absolutely talk to our clients about whether they're caught by the circumstances in this decision from 2015 and whether that should be addressed. So it's calmed down a little bit from what it was when it first arrived. All the banks got very skittish, but still, from a seller's perspective, if your agreement's caught by Gallery V, it's much better to deal with it, because at that stage then, whoever your buyer, eventual buyer, or if you refinance, whoever that is, you're open to the world at large. Some banks won't lend if Gallery V provisions are in the agreements. So you should deal with that. We've got a step process for taking clients through that if they need to. The other thing is that you can't actually add more than 5 years at a time. The Act or the modules specifically prevent that. So you can't make that purple one 6. You can make it 2 or 3 or 4 or whatever it might be, but you can't make it any longer than that. If you want to go for more than 5 years, the only safe way to do it is to have a brand new management rights agreement. So that's not what we're talking about today. We're talking about varying existing ones, because a new agreement is a whole different story, and that might be another one of these webinars at some stage. So the other thing that changed in 2003 is that voting on a variation of a management rights agreement to create option term or a new agreement is by secret ballot. So for those of you that haven't been through the process, the way a secret ballot needs to work is that there's an independent returning officer engaged by the body corporate, and all votes for that particular secret ballot need to go back to the returning officer. So what'll happen is if I own lot 50, Frank Higginson, I'll get with my AGM agenda, my normal open ballot paper, to vote for Annie and Airlie and whatever for committee and vote yes to the budgets and all that sort of stuff. And I'll get a separate piece of paper, which will be my secret ballot paper. And that secret ballot paper will be relating to my motion to vary my agreements, vote yes or no. I tick yes. I put that inside another envelope, and then I put that inside another envelope to go back to the returning officer, and I complete the back of that ballot paper. So on the back of that one is Frank Higginson, lot 50. So what happens is the returning officer makes sure on the day of the vote that, yes, Frank Higginson's a lot owner. Yes, he's financial. Yes, he's lot 50. That's cool. And he or she, most of the she, will open that. They'll take the ballot paper inside the envelope that's inside and put it in another box. Now that envelope, the second one, has got no identifying particulars on it at all about who I am. So what they'll do is they'll get all of those, put them in a box, and then once they've got them all there, they've gone through all those first ballot papers, they'll open them up, and it's a lucky dip. It's like Christmas. You don't know what you're going to get until you actually count the numbers. So that can be a nerve-wracking exercise if you've got a knife edge, but that's the way it works. And that's been the case since 2003. Before 2003, you could actually ring the body corporate manager and see how the voting was going and chase up the people who you think you need to chase up, but the government shut that down. So there's a whole process about counting the numbers, and Chris and I have started doing some webinars on that. And I think, Annie, if you could put up the link to that now, which is the first one we did, counting the numbers, the politics of Strata, because that's applicable to everything, but also in relation to management rights. So, and here we are, half an hour of me talking to myself, it feels like, sorry. After it's lodged, it's got to go on the agenda. The body corporate can get legal advice on it, and quite a lot of them do. The body corporate can ask you to pay legal costs for that, but you're not obliged to. Sometimes I think it's a form of insurance if you actually do, because obviously if a body corporate lawyer sanctions it and it goes up and the committee likes it, then it's almost guaranteed success. And really, probably there is another, and Chris and I are talking about it, the dark arts of lobbying. And to be honest, I mean, we try to give a lot of information in these things, but that is something that we do a lot of, and I'm not going to really tell everyone how it happens, because that is an art. It's a really, really interesting exercise. So looking at some of the questions, Ron, thank you for joining. So what have we got? The committee's refused to take a motion to either AGM or EGM state it's not us future managers. How can we encourage the committee to place a motion on the agenda? Excuse me. To me, what you'd be doing is getting a lot owner to do it for you. Take the committee out of the loop. If the committee's not being helpful, a friendly lot owner hopefully will do that for you. And I suppose if you don't have a single lot owner that would support you to do that, then you're in a very bad spot. That's just the practical reality of it. Sorry, Ron there, and Annie. Alexandra, how do you encourage owners to vote for a top-up? put your details in that second link that Annie's put there, and I'll send you a seminar I did exactly on that in a start. And I think probably for me, the answer is, if you want it in a nutshell, it's that it's not the first time that people hear from you is not, hey, my motion's getting voted on next week. Can you please vote yes? Because at that stage, what do people owe you? You know what I mean? That's the reality of it. So you got to have relationships with people. And my experience with these things is that almost no matter what, if you have good relationships with your owners from a management rights perspective, you will win these things. That's just the reality of it. If you go around picking fights with everyone and making enemies, then you're not going to win. Well, not going to win. You may not win. And I've seen some very contentious stuff get up, and Gallery V is the same thing. Like Gallery V is actually a really technical, difficult thing to understand. And I say to clients all the time, if your body corporate gets on with you, most people won't even read it. Dominique, could a top up be automatic every year? No, not the way. I've seen some people try to do that. I don't think that works from a legislative perspective. I think you physically need to put up a motion and a variation. And there's one client in particular we had for a building that was of management rights business of very substantial value, probably north of 5, bit less than 10 million, that is. And they were in a standard module. So every year we would top them up. We'd get them one more year. Glennis, thanks for joining again. Mentioned when exercising options, best to get a deed signed. So the deed is just basically where the body corporate acknowledges that the option was validly exercised, and that then goes on the body corporate record. So it's between the body corporate and the manager, refers to the manager exercising the option by giving notice by whatever date, and the term of the agreement is now extended, our yellow one again, for that 5-year period from 2021 to 2026, for example. And that deed then goes on the body corporate record. So that's not too complicated. It's not as complicated as what the variation process might be. So yet again, we've rolled through to 2:30 and I've just had a monologue. So thank you, ladies and gentlemen, for joining. I suppose if you aren't a client, use that upload link to give us your documents. We'll come back to you. And we've got a box there. If you're not sure where your documents are, we can help you find them. So if you don't know where they are, and to me, that would be a truly terrifying thing, because if you can't answer the question of whether you've got an option and when you next need to exercise it, then you need to get that uploaded now, and we need to get started, because dead set the options can expire next week. If your agreement's structured that way, you might have a straight 10, 25-year agreement, I don't know. But unless you know the answer to that question, it's truly terrifying. You've got a whole lot of your business value at stake. So yeah, and probably last thing, both of these things for us are complete start to finish services. We give you everything. We lodge it for you. We chase it up. We send you execution copies. We send you thank you letters. We send you commiseration letters. Unfortunately, that happens from time to time. We help you get it there. So if any of you need help, feel free to reach out. So next week, I haven't even checked to see what the webinars are. All I know is that Midnight Friday, I'm out of quarantine, so I'll be in the Valley if anyone wants to come and find me. Joking. No, it's Pilates on Saturday morning, then golf straight after that. So I'm looking forward to being able to walk the dog again too. So thank you, ladies and gentlemen, for joining today. I hope that was worthwhile. As always, welcome your feedback, and Chris and I will be back next week at 2 o'clock. So in the meantime,